court is now in session. The Honorable John Brown, White.
Thank you. Please be seated. Okay, we're here for arraignments. Mr. Cobb, are you ready?
Mr. Jordan and I have something to tell you really quick.
We could handle it just really quickly.
Okay.
Your Honor, this is in reference to Timothy Jordan, 21 CF 2345. We realized, kind of after we left, that we're going to need to sever the possession of a weapon by a convicted felon from the remaining two charges.
Okay.
The intent would be to try the POCS with the resistance without violence. That will remain those two charges to be tried on Friday. We just wanted to let you know that based on everything that we've looked at, that needs to be severed for it to be a fair and impartial trial.
Okay. So it's still 21 CF 2345?
Yeah, sure.
Okay. Okay, when will y'all get me proposed jury instruction and verdict form?
I will work on them tomorrow, and I will send them to Mr. Cobb, and maybe we can agree to have the motion, any motion in limines and the jury instructions to you by Tuesday end of business.
Okay, that'd be great. Okay, anything else?
No, sir. Thank
And
you.
Jordan? Okay, thank you.
All right, see you next week.
Yes, sir. Thank you. Have a great weekend.
You too.
Okay. Mr. Heath, do you have something on the docket on 1:30?
I do, Your Honor, but we are still working on getting squared away.
Amy Michelle, because she's here. And an inmate. Can you get Mr. Cox, please?
He probably got confused because we just handled Ms. Majou and Judge Ketchel as well, so it was probably just a little bit of a, thank you for letting us know.
All right. Can you put Amy Michelle?
And it's 24 CF 924.
Yes.
I thought I'd handle her case.
Yes, sir.
Judge Ketchel.
Right. Hello, Ms. Majou. So you're here in front of me on an arraignment for synthetic narcotic drug production and cocaine distribution, 24 CF 924. Mr. Cobb?
Yes, sir. Jason Cobb on behalf of Ms. Mayhew. I'm going to enter a not guilty plea and ask it to be set for the July 8th pretrial.
Okay. Ms. Majou, I'll see you no later than July 8th, okay? Thank you, ma'am.
Okay. Madam Clerk, is that everything?
Yeah.
Need to check with her, Mr. Cobb. Thank you. Next, we have Stephanie Martin. Ms. Martin, come on up to the lectern, if you will. 24 CF 835.
Your Honor, I believe I filed a no cross in that case.
Yes.
Okay, good. Ms. Martin, your case is dismissed.
Thank you,
Good
sir.
seeing you again.
Thank you. Good
Thank you,
seeing
ma'am, especially with your case being dismissed.
Yes, sir.
Have a great weekend. Thank you. Tyler Miller is next. He's an inmate.
He's not, Judge.
Okay, he's not an inmate. It's 24 CF 901.
Here's the folder back there.
This is my trust.
Okay.
This is my
Okay.
identification.
This is your report.
Okay, all right.
This is Mr. Miller.
Yes, Judge.
Does the state have an offer for Mr. Miller? It's,
Yes, Your Honor.
the charge is vehicle theft.
Let me pull that up, Your Honor. Your Honor, the offer would be a withhold of adjudication, probation for 2 years. We would reserve jurisdiction for 90 days, court costs in the amount of $615, community service and for 24 hours of community service with no contact with the victim, just as loving, And those are the terms, Your Honor.
Okay. And there'd be $40 per month cost of supervision.
That's correct.
Mr. Miller, you have the right to an attorney, you have the right to a jury trial, you also have the right to waive both of those, accept the state's offer. Have you ever been on probation before?
I would just like to enter a plea of not guilty and
Okay.
motion the court to
Yes, sir.
continuation so I can get proper documentation filed for discovery.
Okay.
Yeah.
Won't be a continuation, but I will set your case for the pretrial conference on July 8th. So this is the arraignment. You were given the information that has the charge against you,
I
correct?
have this.
Okay. So you're charged with vehicle theft. I'll enter a not guilty for you. Yes, sir, to the state,
Oh, no, I just wanted, if he's going to be
representing himself.
representing himself, I just want to make sure that I give him my email so that way any type of
Paperwork.
Yeah.
Okay. Mr. Miller, you have the right to an attorney. If you qualify financially, the public defender can be appointed. If you want to fill out a financial affidavit later, you can certainly do that. Okay? I'll see you back here on July 8th at 9 o'clock.
Thank you, Judge.
Thank you, sir. Next per se is Naomi Perez, 24 CF 910. Hello, Ms. Perez. Ms. Perez, do you wish for me to appoint the public defender if you qualify financially? How much money do you make per month? I'm sorry, how much? Okay. Based on that amount, I can't say that you qualify for the public defender. If you want to fill out a financial affidavit and turn that into the clerk on the first floor, if they deny it, then you can appeal it to the judge. So I would state in your affidavit all the costs that you have, if there's any expenses, because the judge has more latitude than the clerk does, okay? So you've been given the information, which is the charging document, charging you with sale, manufacture, and deliver of cocaine. I'll enter a denial for you today. Schedule your case for July 8th at 9 o'clock.
Oh, that's not a rescheduling for,
Not rescheduling this, it's scheduling pre-trial. So fill out the financial affidavit if you want to seek to qualify the public defender. If not, you'll need to hire a private attorney. I'll see you back here July 8th at 9.
thank you.
Thank you, ma'am. The next person say I have is Darian Scruggs.
Who'd you call?
Mr. Sergeant? Hello, Mr. Sergeant.
Jason McKinney on behalf of Robert Grant Sargent. He's here in two cases, 24 CF 8887 and 24 CF 888. We would acknowledge the receipt of 2-count information in each of these cases and a plea of not guilty. Ask for the next available pretrial date, which should be July 8th.
Yes, sir. Mr. Sergeant, when I looked out in the gallery and saw your folks, I don't know what my feelings were. I just hated that you were back before the court, you know, in the courtroom. The last time that we saw each other, I was hoping that I'd see you out at another chicken and egg where I saw you before you were in court. I'll see you back here in court no later than July 8th, okay? And again, I appreciate your folks being here.
And Judge, that does lead me to a request from his folks. They are the listed victims in the 887 case.
Okay.
Currently, there is a no contact provision that precludes them from speaking with him at the jail. This is not a bond hearing, but I am asking the court if the court would consider changing the no contact to no violent contact for purposes of them speaking with Mr. Sargent at the jail.
Yes, sir. Any objection from the state? Okay. So, Mr. Sergeant, I'm changing the no contact to no violent contact. Okay? Okay. I'll see you July 8th. Thank you. Thank you to your parents.
Judge, I also have Rebecca Tillman, who's present in the courtroom.
Hello, Ms. Tillman.
Ms. Tillman is approaching in 24 CF 717. We're here for an arraignment today in 24 CF 717. We would acknowledge the state has filed a 1-count information, waive its formal reading, and enter a plea of not guilty.
Okay. Ms. Tillman, I'll see you back here on July 8th at 9 o'clock. If the state offers you something that you want to accept before then, Mr. McKinney can set it for a hearing. Thank you, ma'am.
Judge, I also have Clarence Ward before the court in 24 CF 948.
Okay, thank you. Hello, Mr. Ward.
Mr. Ward is here in 24 CF 948. And I believe, and I do not want to speak for Mr. Snell, but I believe that the state is deciding which charges that they intend to file on, and there's not currently an information.
Okay.
We're working through a charging decision here on the case, and we're not ready for that today.
Okay. So you want to continue Mr. Ward's case until the next arraignment date, which I believe is June 13th.
Yes, Judge.
Okay. So, Mr. Ward, I'll see you June 13th at 1:30, okay? Thank you.
Thank you, Judge.
Thank you. Mr. Koch?
Yes, Judge. Mr. Mark Payne, who's present and approaching, Your Honor.
Hello, Mr. Payne.
Hello, Your Honor.
Thank you. Your Honor, we'll be entering a not guilty, 2-count information, waive formal reading, and request to be kept on the 7/8 docket.
Okay. Mr. Payne, I'll see you back here on July 8th at 9 o'clock. Stay in touch with Mr. Koch.
Yes, Your Honor.
Thank you.
Judge, next I have Mr. Marshall Rodney, who's present and approaching.
Hello, Mr. Rodney.
Your Honor, we'll be entering not guilty to 2 counts of information, waive formal reading, and request to be kept on the 7/8 docket.
If I
Mr.
can,
Rock? Yes, sir.
may I say something?
Certainly.
If he had any interest in resolving the case at all, he could enter a plea today to 2 misdemeanors. Today.
So it'd be an adjudication of guilt?
12 months of probation, batter's intervention. I believe it'd be $622 in court costs, and no contact with the alleged victim.
Court costs $150 public defender's fee,
Yes, sir.
$40 per month cost of supervision.
Yes, sir.
Okay? You say that's for today,
Yes, sir.
kind of implying that it may not be on the table later.
That's correct.
Mr. Rodney, one of the things that the case law says I can't do is I can't make the state leave an offer open for a period of time. Separation of powers prevents me from doing that. So that's what the state's offer is now. I don't know how long they'll leave that open. If they leave it open, you have the right to a jury trial that you'd be waiving if you accepted that offer. But it's up to you what you want to do.
Judge, if we may just pass this up briefly so I can just talk privately outside.
Good. Okay. I'll see you later this afternoon.
And then last one in the gallery, Judge, Mr. Peter Rybeck.
Mr. Rybicki, how are you doing? Good. Doing well. Thank you, sir.
Just take this out. Your Honor, we'll be entering a not guilty, waive formal reading, and request it be kept on that 7-8 docket for pre-trial.
I'll see you back here on July 8th. Stay in touch with Mr. Koch. Thank you.
Okay. Yes, sir. That's all I had, President, if I may go talk to my client.
Yes, sir. Mr. McKinney?
I don't believe I have any further, Judge.
Okay.
Yes, again, attorney-client?
Ready, Mr. Heath?
We are good.
Yes, sir. Please.
Good afternoon, Your Honor. May it please the court, James Heath on behalf of Jonathan Lee Yates. Appreciate the court's courtesy in letting us come back in and get this done.
Yes, sir.
Your Honor, forgive me, it's been a minute since I entered a plea before you. Although it's been reduced to writing, are you going to have me recite it, Your Honor?
If I can understand it, no, sir, I can just read it.
May 23rd. May I approach, Your Honor?
Please. Thank you, sir.
Your Honor, as previously discussed, Mr. Yates is going to withdraw his previously entered pleas to not guilty on all 4 of the reflected cases and enter a negotiated plea with the terms articulated before the court now.
Okay, so it would be 25 years DOC on the felony counts,
Yes, Your Honor.
and that's other than the smuggling. What would be the sentence on 20 CF 438?
That would be 5 years. It would run concurrent with all others, along with the other third-degree felonies, Your Honor.
Okay, are there any lesser included? They're all as charged.
They are, Your Honor. There's misdemeanors, and all the misdemeanors will be as well. That's articulated under
Right.
terms of the plea as well.
So all the misdemeanors would be time served,
Yes, sir.
and there's only one felony that is less than 30 years is the maximum. So that's the 20 CF 438, correct? And that's 5 years?
Yes, Your Honor. The fines and court costs are articulated on the, I believe, the third page, Your Honor.
Okay,
We ran
thank
out
you.
of room, so that's why we put it like that.
Thank you.
And I have a sheet I can recite if we need to.
And you were court appointed?
No, Your Honor.
Private.
Private retained.
Okay, good. Okay, Mr. Yates, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. For the record, this is case numbers 24 CF 682, 20 CF 988, 20 CF 438, and 20 CF 434. Mr. Yates, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
High school.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Yates, has anyone promised you anything other than what's in the written plea agreement?
No, sir.
Has anyone forced, threatened, or coerced you into entering the plea?
No, sir.
Any questions for me or your attorney of the state?
Mr. Yates would respectfully request the court allow I believe it's a recommendation to DOC for a facility somewhere near Okaloosa County.
Absolutely. Yes, sir. Mr. Yates, I do accept your plea. I find you alert and intelligent, that your plea is freely and voluntarily entered, that you understand the nature of the charges against you, and are represented by competent counsel with whom you state you are satisfied. I find that there is a factual basis for acceptance of the plea. You're adjudicated guilty. You're sentenced to 25 years with the Department of Corrections. In each felony count, other than 20 CF 438, you're sentenced to 5 years with the Department of Corrections. All of the sentences are to run concurrently, run at the same time. All of them are with credit for all time served. On the misdemeanor counts, you're sentenced to time served. All court costs, all monetary obligations are required by statute or ordinance are imposed. That's the court cost. Okay, and you mentioned there were other costs. In 20 CF 434 and 20 CF 988, there's a $500,000 fine in each of those. In 24 CF 682, count 2 and count 3, there's a $50,000 fine on each of those. All of those will go to, and all financials will go to a civil lien or judgment. Did I miss anything?
Not that I see, Your Honor.
Okay. Mr. Yates, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Thank you, Mr. Yates.
Your Honor, that's all I have for the court this afternoon.
Yes, sir. Thanks, Mr. Heath. Have a great weekend.
You too, sir.
And the state will get me a score sheet, I take it? You'll get me a score sheet?
Yes, sir.
Good, thank you. Thanks,
And
Mr.
we
Heath.
did review the previous, and I know what the edits are, Your Honor, so there will be any follow-up. Yes.
Good, thank you. Mr. Koch?
Yes, Judge. If we could recall Mr. Marshall Rodney.
Mr. Rodney?
Judge, we reviewed that offer that was on the table this afternoon. We'd like to still keep it to not guilty and keep it set for the 7/8.
Okay. Mr. Rodney, I'll see you back here on July 8th at 9 o'clock.
Yes, sir.
Thank you, sir.
Judge, I also have Mr. Raul Perez in the courtroom. He's present and approaching.
Okay. Hello, Mr. Perez.
Excellent, thank you. Your Honor, we'll be entering a not guilty, waive formal reading, and request that it be kept on the July 8th pretrial docket.
Okay. Mr. Perez, I'll see you back here on July 8th at 9 o'clock. Stay in touch with Mr. Koch. Thank you, sir.
Schedule appointment. That's our next appointment. Yep. Judge, I also have Mr. Jonathan Russell, President of the courtroom.
Hello, Mr. Russell.
Just we're here in two case numbers, 24 CF 893, 24 CF 914. We'll be entering not guilty to all counts, waive formal reading, and request it be kept on that July 8th pretrial docket.
Okay. Mr. Russell, I'll see you on July 8th.
Yes, sir.
Thank you.
Call this down. That's a good appointment. Come see you, sir. Okay. Your Honor, lastly, I have Mr. Christopher Smith, President of the courtroom, in 24 CF 929. Thank you. Your Honor, we'll be entering not guilty, waive formal reading, and request to be kept on the 7-8 pretrial docket.
Okay. Does the state have an offer for Mr. Smith? Okay. Mr. Smith, I'll see you on July 8th at 9 o'clock.
Yes, sir.
Thank you, sir.
Call this number next week, that's my secretary. Schedule an appointment to see you. Okay? Yep. That's all I have, Judge.
Thank you. Madam Clerk, who's up?
Teddy Leno.
Lanu?
You're going to see Mr. Lanu. I know we're going to be here for a little bit longer if the court will allow me to pass this to the end of the docket.
Yes, sir. We'll pass it.
Ricky Morris.
I'm sorry, Ricky.
Mr. Morris, he's in makeup.
Okay, thank you. Mr. Potts.
He's on both, I believe they're not in one second.
Thank you.
Yeah, legal services generally cases and so I think that's yeah.
Yeah, this is Ricky Morris. He is two cases on today's docket, 24 CF 1012, 24 CF 2. At this time, Mr. Morris is going to be entering, it's 52324. At this time, Mr. Morris is going to be entering a no contest plea in 24 CF 2 that is going to be as charged. In 24 CF 1012, there is a 3-count information. Count 1 in the information is grand theft from a dwelling. Mr. Morris is going to be entering a plea to simple grand theft from a structure. He'll plea as charged on counts 2 and 3. And I think I said this, but in 24C2, it'll be a plea as charged on both counts. In the 24CF2 case, Mr. Morris is going to be placed on 3 years of probation. He will perform 24 hours of community service. He will have no contact with Michael Williams. The court will reserve jurisdiction for 90 days to determine the restitution in the 24CF2 case. In 24 CF 1012, Mr. Morris will be placed on 3 years of probation concurrent to the probation in 24 CF 2. He will pay $1,040 restitution to Gen, the Chinese restaurant. He will have no trespassing at any Gen. He will be assessed $615 in court costs for each case. One $50 application fee, and then 2 $100 public defender fees, and he's previously been adjudicated, so it would be another adjudication.
Okay.
May I approach?
Yes, sir. Thank
And
you.
I kind of apologize, I was all over the place
Thank you.
in writing up the terms, so I was trying to announce them more succinctly than what's included.
Thank you. Mr. Morris, if you'll raise your right. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand down. Mr. Morris, did you read the plea agreement?
I did.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
I did.
Did he answer all of your questions?
He did.
Are you satisfied with his representation?
Finally, yes, sir.
Okay. Did you sign the plea agreement?
Yes.
As Mr. Klein states, the plea agreement's handwritten. The sentence that Mr. Klein's announced today, is that what you agreed to?
Yes, sir.
Okay. Any questions for me or your attorney of the state?
No, sir.
Mr. Morris, I do accept your plea. You're adjudicated guilty. Count 1 is to the lesser included offense. You're sentenced to 3 years probation in each case and count. They're to run concurrently, run at the same time. You'll need to pay $1,040 in restitution in the 24 CF 1012 case. The court awards restitution, but reserves jurisdiction to determine the amount of that restitution. In the 24 CF 2 case, if the state files a motion or a petition seeking that restitution within 90 days from today, you'll need to pay the court costs in each case, total of $250 public defender's fee, $40 per month cost of supervision, have no trespassing at any Gin Gin restaurant. Thank you, sir.
Is the misdemeanor time served?
On the misdemeanors, yes, ma'am.
Yes.
Time served on those. Thank you.
I figured that's what we wanted to change. They have
Okay.
Marty was appointed to a new case and filed a motion to withdraw. If he's here he's got a new case that I'm not.
Okay. Mr. Nettle, are you here for Mr. White's case?
Well, not the one that's on the 130 docket. You
Right.
appointed Marty Noakes on that. He filed a motion to withdraw, I saw.
Right. So on Mr., what case number is?
So the one that's on the 130 docket is 24 CF 1003, and Mr. Noakes is on that case.
Okay. And his motion to withdraw is granted, and I appoint Mr. Nettle to that case. Do you want to do all the cases at 2:30? Do you want to do?
I'll leave it up to you, Judge. I need to speak to Ms. Loomis first. But,
Okay. Why don't we wait
I
until?
just spoke to Mr. White. I'm ready on him.
Okay. Yes, ma'am.
Right, that white would be.
Is there an information for Mr. White?
Yes.
Good, thank you.
That was 1003, is it, Madam Clerk?
Yes.
Write that case number down. Oh, okay, thank you.
Hello, Mr. White. Mr. White,
Judge, we would enter a not guilty plea on the 1003 case. You just appointed me to represent you on the case. And ask that it be set with his other cases.
okay. Are the other ones set for July 8th?
Yes, Your Honor.
But we have a hearing today at 2:30, right?
Yeah, we're set for 2:30 today, and
Okay.
I mean,
So the underlying case is set for July 8th, but as far as the 2:30 hearing, you want to do that now, Mr.
that's
Null?
fine with me.
Please.
Judge, we're here on his motion to set or reduce his bond. He was arrested February 7th of 2023. Actually, he tells me that's when they was actually booked on one charge, but he was actually arrested initially on 1/21/23. So he's been in jail about 17 months now. His case is he was a juvenile when he was arrested. He was direct filed to adult court. He's
Yes, sir.
currently being held on no bond on most of his cases. He does have a bond set for at least 3 of his charges. He's currently 18 years old. He would reside in Fort Walton Beach with his mother. He's been determined to be indigent. He cannot afford a high bond. He's been seriously struggling with severe mental health issues since he's been in jail. I'm sure you're aware of that.
Yes, sir.
He's been Baker acted at least twice. At the time I filed for this motion, he was being held in solitary under suicide watch. He's since been out, released back into, he's still not in the general population, but he's not on suicide watch anymore. We're requesting that his bond status be set to a signature bond with a pretrial release, or in the alternative, a $10,000 blanket bond for all cases. Mr. White would like to address the court, and then I have some further things to ask.
Okay. Mr. White, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down.
If you don't mind, can I read a letter?
Yes, sir, you can certainly do it. Know that if you say anything factually about any of your cases, everything's being recorded. It can be used against you. State sitting to your right, okay?
Yes, sir.
Yes, sir.
Speaking to anybody in the fact of the case. All right.
I do not need to be in jail any longer. I need help. Help that the jail cannot give me. All the jail has done is make my mental health worse. The longer I stay locked away in here, the more they're going to continue to pile up more charges on me. I need help. Jail is not helping me at all. I've been here almost 2 years and it's done nothing but cause me trauma and make me worse off. May I please be granted a bond today so that I can get away from this environment. I'm not in the right mind frame to deal with this behind the wall. Please hear me out, try to understand me. The longer I'm here, the longer I'm just going to continue to get abused mentally and physically. This has driven me insane. Something has to give. I'm desperately crying out to you. I can't take anymore. I'm willing to take and follow any court order sanctions. I'm willing to wear a GPS monitor if I have to, whatever it takes. I'm willing to go to inpatient or outpatient services or facility. I keep asking for help, and I'm not getting it in jail. It's not going to change unless I'm out of jail and in an inpatient facility. I did really good when I went to the hospital on a Baker Act. I was actually getting help from people who cared. Now I can't even go there unless I'm released. I'm also supposed to be graduating high school this year, and me being in jail prevents me from accomplishing that goal. With all due respect, Your Honor, I ask you today to please help me get help and grant me a bond.
Okay.
If I can follow up on some of that, Judge, you did appoint a psychiatrist to interview Mr. White. That appointment is scheduled for June the 4th.
Good.
Her office is in Fort Walton Beach, so if he was to be released on bond, he could schedule an appointment at her office. The other thing is, even if you grant him a bond today, or a blanket bond, or a pretrial release with a GPS, he would not be released. He's got a hold from Palm Beach County, which I think we've discussed in the past.
Yes, sir.
And if he was to, he would go, and if he was to be granted a bond and then released to Palm Beach County, that would solve one of our problems here. The state has just today, we talked about a youthful offender sentence.
Good.
And Mr. White says he would like to consider that in the meantime. But the problem with the youthful offender sentence is if he enters a plea here and gets sentenced on all those charges, when he goes to Palm Beach County, his score sheet's going to be yay long. Whereas if he could be released to Palm Beach County now, he doesn't have anything on his record, and he would most likely get time served or probation at the most. I don't think he would even score more than 22 points.
Yes, sir.
So that's something for you to consider. And if you
Okay, what
are
is-
not inclined to give him a bond, we would ask you to issue an order releasing him to the hold on Palm Beach County with a detainer for Okaloosa County so we can take, I have tried numerous times to contact the state attorney in Palm Beach County. Her name is Christy Rogers. I've sent her numerous emails. I've called her office and left voicemails. I've called her secretary. And recently have not gotten any response from her. I know Mr. Snell said he's tried to call her and not received any response. I mean, I think the best thing we could do, possibly do in this situation is, one way or the other, get Mr. White to Palm Beach County so he can address that case, and then come back to court here so we can address these cases.
Okay. Mr. Nettle, the appointment with the doctor on June 4th, it's an evaluation to determine if he's competent to proceed?
No, I think, in speaking to Mr. White, I actually believe he is competent. It's basically twofold. One, for mitigation purposes.
Okay.
Because at one point, Mr. Snell and I were talking, and he had not indicated any agreement as far as youthful offenders, so it was going to be a straight-up plea. So that psychiatrist was going to be used for purposes of sentencing.
Okay. Good.
But I think Mr. White does need to, I'd like to hear what she has to say about his mental health status.
Okay.
I don't think the jail has addressed his problems.
To the state, what about
Would the
releasing
state-
Mr. White to Palm Beach County and putting a detainer on him?
The state would not object to that.
Okay. Mr. Nettle, if you want to prepare a proposed order that grants that, then I'll sign it.
So that would that be a release to the Palm Beach County hold with a detainer for Okaloosa County?
Correct.
Okay.
Yes, sir. And then just to make sure that it totally doesn't fall off my radar, let's set it for July 8th. All of his cases for July 8th.
That's fine.
Okay.
What should we do about it? Should I notify the psychiatrist? He'll probably be released before the June 4th appointment, so.
I don't know. That's a week and a half away.
I'll get in touch with her, and I'll get in touch with the jail and see. I doubt Palm Beach County is going to come up here that quick to get it.
Right. It'd be nice to have that evaluation before he leaves.
Yes, it would be.
Yes, sir. Mr. White?
I was gonna mention that, I was told by my mom, aunt, that Palm Beach County they told them that they don't extradite. So I would just be sitting here waiting for no reason to extradite me. That's what I was told, but I don't know.
And that's why I've got you, I'm going to keep you on July 8th at 9 o'clock. As far as giving you a bond, you know, when I was doing my homework, I looked at all the case numbers and I wrote down just some of the charges in 22 CF 666, concealed weapon, 22.
Well, I'm sorry, that particular charge, the state's agreed to drop because that was his mother's account.
Okay, good. Okay, are you null-processing that now?
No, sir.
Okay. I'm just playing the hand I'm dealt. Then 22 CF 667, fleeing and resisting law enforcement, and then it says aggravated. In 24 CF 523, resisting law enforcement with violence. There are 2 counts of that. 24 CF 1003, battery on an inmate. So with those, as much as you need the help, I can't just release you with those charges out there. Even with a GPS monitor, all those things, I'm concerned about the safety for the community. So respectfully, your motion to reduce or set bond is denied.
Judge Brown, what about him to the hospital?
No, ma'am. He's got an attorney, and unless one of the attorneys calls you as a witness,
Okay, and then there's a better time today.
I did sign the Baker Act today on Mr. White. Mr. Nettle, just so you know, his mother filed paperwork for a Baker Act, and I did find the requirements for that fulfilled, so I signed that today.
Is that just recent?
Today, at lunch. Okay?
Judge Brown, they don't take me to the hospital anymore. They put me in MHU and just keep me there, naked.
I understand. So, Mr. Nettle, I don't know what complication that's going to cause for Palm Beach County. But again, so I talked to the jail about, are they going to release him if Palm Beach County comes up with that pending Baker Act? I don't know how that works.
I doubt Palm Beach County will be here before that takes effect. So.
If they will transport. There's been a lot of discussion between the judges of the jail not taking the inmates to Baker Act. So I'm not sure exactly where that has ended. Okay. But I'll follow up on the Baker Act, and I may need to amend that judgment if I can figure out exactly what the jail is doing and not doing in relation to the hospital and Baker Acts. Okay, so I'll keep that and I'll do some work on that.
So what's going on right now? I'm sorry, I'm confused.
Your mom filed a petition today, I believe, at least I received it today, that said that you told her that you were biting yourself, and that you were considering suicide. And so based on that, I signed the order for Baker Act. But I will follow up as far as the transition between the jail and the Baker Act facility. And I understand your frustration.
Judge, I know his mother cares about him, but now he's going to end up back in suicide watch, in solitary confinement, in chains. And I understand that she's concerned, but I think,
That's wrong in the hard place. I had no choice.
I will check with the jail and also the hospital and figure out that part of it, okay? So that'll be my homework. I'll do that depending on when I get off the bench, either today or tomorrow, okay? So I'll see you back here on July 8th if Palm Beach doesn't come and get you.
There is going to be an order.
Correct. Yes, ma'am, and he shouldn't be released until I sign that order. Right.
Your client asked me to. The client asked me to. Thank you,
That's
sir.
all right. You can come out.
Are you going to be safe, Elijah? Come on. Your client asked me to try to cancel.
Okay, Madam Clerk, on the 130, anything left?
I'm just telling you
Mr. Lanu?
Yes.
He's here.
Thank you, ma'am.
Mr. Blaine, come on.
This is Mr. Lanu. He is present. We do have a two-count information. We will waive the formal reading, enter a not guilty plea, and just ask that this remain set on the July 8th docket. I will say, I do expect probably to have to file a motion to continue because of the suppression issue and oppose the officers, but I'd like to keep it on until they have to take it off.
Okay. Mr. Lanu, I'll see you back here July 8th at 9 o'clock.
All right.
Thank you, sir.
That's your court date. But like I said, we'll talk.
Anybody else on 130?
That's all I have.
Okay. As far as the 2:30 docket, what are we ready for? Mr. Patel?
Judge, I just need a second to review for my client. We can put it back.
Mr. Little just went around to speak with his, so after him.
I'll take my chances and he can.
Okay. Sounds good.
Sounds like it could have been a long time.
Elvis Presley, correct?
Yeah. Yes, Judge.
Good.
The
17.
king is back in the building.
17 CF 1339. And they stopped the foreclosure sale of Graceland. Hello, Mr. Presley.
That's me.
Yeah. That's why I wasn't here. So I drove over there and talked to him. Come right over.
Good afternoon, Judge Jay Patel on behalf of Elvis Presley, 17 CF 1339. He's before the court on an allegation of a violation of probation. I have entered a denial at this time. Mr. Presley would be admitting. The understanding is that he would admission be no contest. The understanding is that it's a modification to take it outside of the guidelines. His probation will be reinstated with the original terms. He'll pay a $50 VOP fee. His GPS monitor shall be attached prior to his release from the Okaloosa County Jail. He'll serve 30 days in the 30 days of jail with credit for time served. The state stipulates that that time has been served. I've spoken to his wife, who's spoken to probation. And I'd like probation to speak up now, just to make sure we're all tracking.
Okay.
He's domiciled in Palm Beach County. Palm Beach expects him to, once he's released, to immediately head down to Palm Beach to check in. I don't know if...
Probation, does he need to check in here before he leaves? Or can he go straight to Palm Beach to probation there?
Never had anybody just go straight down, to the county that they live in. They usually have to go to our office. So no one said anything to me. All it says is we'll need GPS if released. That's the only note they have on the docket.
Okay, so,
See if they put a case note in our system.
okay.
And it will be a $100 VOP fee.
Okay.
Right, not the 50, correct? And then the adjudication is what?
Guilty.
Thank you, ma'am.
All we're doing is just reinstating and putting the GPS on.
30 days in Okaloosa County Jail with credit.
He has to have GPS consistent with his probation.
Okay. Yes, ma'am.
That's correct, Judge. The state is doing so based on the VOP recommendation that suggests his supervision should be reinstated with credit for time. So we are following the patient's recommendation.
Okay. It's not, is it with credit for time served, or is it 30 days and you acknowledge he's already served?
It's the 30 days, Judge.
Okay.
There was some confusion because he was not booked into the jail up here right away. He wasn't transported immediately from South Florida. So we're stipulating he has 30 days. He's served more than that.
Okay. Mr. Presley, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Presley, do you have this in writing, or is it?
I do. May I
Please,
approach?
please. Mr. Presley, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes.
Did you discuss it with your attorney?
Yes.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Presley, I do accept your plea. You're adjudicated guilty. Your current supervision is, all the original terms and conditions are reimposed, and it's modified so that you're sentenced to 30 days in the Okaloosa County Jail with credit for all time served, and the state stipulates that you've already served that time. You'll need to pay the $100 violation and probation fee. You'll need to wear a GPS monitor before they let you out of the jail. Court has no objection to you having your supervision in Palm Beach County to the...
I was told he has to come to our office first.
Okay. If you're released before 5 o'clock today, you have to report to probation here. If you're released after 5 o'clock, then you need to report tomorrow morning at 8 here at probation here before you leave. Okay?
Yes, sir.
Thank you, sir. Thank you, Mr. Presley.
Thank you, Judge. May I be excused?
Yes, sir. Thank you.
Your Honor, I don't have any further business either. I had a Mr. Saxton this afternoon, but that's been moved to July, so if I
Okay.
can dismiss or...
Yes, ma'am. Thanks, Ms. Barrett. Have a great weekend.
Thank you, you too.
Thank you. Okay. Thank you. Hello, Mr. Mackoff. Good, how are you?
Your Honor, this is Mr. Mackoff. He's before the court on a motion to reinstate and reduce bonds. That thing that we've been talking about has not come to pass, so I'm just going to argue the regular bond motion. I would like to take some brief testimony from Mr. Mackoff.
Please, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can put your hand down.
So, Mr. Mackoff, what's the primary reason that you're requesting the court consider reinstating the bonds here?
Family falls off, cause, my family, financial, with my girlfriend and I worked together the last 5 years, and she's just not capable of doing it herself. We had a vehicle that was taken, it's been impounded, it was told where somebody stole it, and she's not an owner. And I know all these things are solvable, but it's a lot of stuff that's not, I could really would appreciate if I could try to get back out on my own. But I don't know if you look at my record, I know it's not good, it's a light years from where I was 15 years ago, and it's been a long time since I've been in trouble. I would just really appreciate the opportunity to get.
Okay. Thank you.
Mr. Mackoff, do you own a business?
Yes, sir.
What kind of business do you own?
Pressure washing.
Are you
I'm
the sole?
sorry, what kind of business?
Pressure washing.
Thank you.
Pressure washing, salt washing.
Yes, sir.
Are you the sole owner of the business?
Yes, sir.
Who else is a co-owner?
Christie Sale on Brooklyn.
Do you guys have any employees?
No, sir.
Okay. How long have you had that business?
4 years, we've been full time.
Do you have any kids? All right.
She does.
How long have you lived in this area?
1990.
Oh, wow. Okay. Do you have any prior failures to appear?
No, no,
I don't have any other questions, Your Honor.
Any questions from the state?
Do you recall a failure to appear that you were adjudicated guilty on in 1990?
Sorry?
Do you recall being adjudicated guilty of a failure to appear in 1990?
I do not. 1990.
I have no further questions, Your Honor.
Okay. Mr. Kleins, anything else?
Mr. Mackoff, how old were you in 1990?
I was 18.
I have no further questions, Your Honor.
Thank you. Argument?
Yes, Your Honor. So, Mr. Mackoff was out on bond in 23 CF 402. This was a $20,000 cash or professional bond that he posted in February of 2023. Mr. Mackoff has made every court appearance that he needs to make in that 23 CF case. He has never missed an appointment with me. We are asking the court to reinstate that bond. That bond was revoked after he was arrested in 24 CF 746. That arrest, the offense date in that case is from February, but the arrest was not effectuated until March 28th. One of the reasons that I'm asking the court to consider this is the main case officer in the 24 CF 746 case is currently on indefinite administrative leave pending an investigation into a shooting here involving a civilian. He has already contacted our office on other cases and said he cannot participate in deposition practice and submit to depositions while he's on administrative leave. So essentially it looks like this 746 case is going to be stalled until he comes off of leave. In 23 CF 402, this is a minimum mandatory situation. Mr. Mackoff, knowing that he has a minimum mandatory, has continued to come to court, make his appointments with me. I would say one of the two primary purposes for bond is to assure appearances in court. Another one is to assure that laws are being complied with. In the 24 CF case, Mr. Mackoff has indicated that there was a passenger in the car. The passenger was left in the car while Mr. Mackoff was outside talking to the officer, and then lo and behold, drugs are found in the car and the passenger says, oh, there it is, after he's been in the car by himself. So that's certainly something that we need to investigate through depositions, but I don't think we're going to be able to do that until this deputy comes off a suspension. So therefore, we are asking the court to consider reinstating the bonds in the 23 CF case. I know the bond motion asked to reduce all of the cash or professional bonds to signature bonds. If the court is hesitant to just grant and reduce everything to signatures, I would suggest maybe the court reinstate the bond in the 23 CF case. And if Mr. Mackoff wants to get out on bond on the new case, he can post a new cash or professional bond. That would put him back with the bondsman. But we're just in this kind of situation where the new arrest, it sure doesn't sound like it's going to be able to be processed the way other cases are, pending this suspension that this deputy is under right now. So we're just asking the court to consider primarily to reinstate the bonds in the 23 CF case, even if the court doesn't want to reduce those bonds. Until those bonds are reinstated, he's not going anywhere regardless of what he wants to do.
To the state?
The state acknowledges the position that the arresting deputy is in, Your Honor. However, in this situation, I don't think the defendant should be treated differently just because of that. This is not a situation where this was a new law violation and that's the only violation that he had. This was a situation where he was out on bond for another case and then committed another crime. And so for those reasons, I mean, I can go into the rather extensive history that this defendant has, some of it violent, some of it drug related. However, I think the biggest point here is that but for that deputy, any person in Mr. Makoff's situation would be held without bond on the 23 case, the 23 CF 000402, because he committed a new law violation while out on bond. He's shown this court that he's not willing to follow the law while he's out on bond. He shouldn't be given yet another chance to do that simply because of a situation that this deputy was in that had nothing to do with Mr. Makoff. And so for those reasons, Your Honor, we respectfully request that the bonds remain revoked on 23 CF 000402.
Okay. The docket just showed jury trial review and didn't show a bond, so I haven't done my homework. So if you'll give me a moment. Okay. Mr. Collins, anything else?
I think if the court would allow Mr. Makoff to address court one last time.
I just want to say, I mean, I know my record is extensive. I'm not the person I was, and I'm still, it's a struggle. I mean, I spent 26 of my first 47 years in prison. And I got out with nothing 5.5 years ago. And I mean, it's been a struggle to get to this point. And I mean, the things that people were learning at 20, I didn't learn. And it's still a struggle learning today. And I mean, that's not to say that that makes it any different for me, because I should have been learning at 20, but I wasn't. And I mean, but I know I'm trying. I'm trying to go in the right direction. I've made some bad choices. The weight of everyday life that most people start learning at 20, I didn't learn. And I mean, that's what I'm at. And I appreciate your consideration there. So.
Mr. Makoff, it gets a lot of traction with the court, what you say. I hear what you're saying. The thing that works against you, and I'm not looking back at anything past the 2023 case, but when I see charges of trafficking in methamphetamine and then narcotic equipment, possession of marijuana, and then it was admitted that the alleged incident happened in March for the 24 case, and it has drugs in there, and the affidavit says a glass pipe with white crystal residue was found in his right front pocket, meaning yours. It's more than just there were drugs in the vehicle where there was a passenger that bird dogged you and said they were yours. And so with drugs, especially with the trafficking in 23, with the allegations of the new case, the reason why I stop is the law enforcement officer. I don't think justice stops just because an officer's on administrative leave. if there is some motion that you want to file to, to advance that, but the court's not going to stop because administratively somebody's on leave and therefore you can't depose them. I don't understand that. So if that comes before me, I'll certainly rule on it, because I don't think that will stop Mr. Mackoff's case. If we have a hearing and someone proves, yep, under this, I can't force him to do that, then, so at this point, I'm denying the motion for bond, but it's without prejudice. If the court says I can't force the law enforcement officer to give his deposition, then certainly bring that before the court again.
Yes, sir.
Okay. So, Mr. Mackoff, I'll see you no later than July 8th. Thank you.
Your Honor, I have one more individual on the docket for today. It's Ms. Owensby.
Your Honor, at this time, we've spoken with the officer victim in this case. We deposed him. During those depots, he expressed that as long as Ms. Owensby is getting some mental health treatment, that he would be okay with dismissing this case because he does understand that it was a mental health episode. We were provided proof that she is undergoing and has undergone extensive mental health treatment since the date of this incident, and so for those reasons, we would be announcing a null pros of this case, Your Honor.
Okay. Ms. Owensby, your case is dismissed, okay? Can you hear me, Ms. Owensby? We can't hear you. If you just give a thumbs up, your case is dismissed? Good. Thank you, ma'am, for the record.
Shay, if you have any questions, just call my office, okay? I'm going to be out of the office tomorrow, but I'll be in next week if you have any questions, okay?
Thank you, ma'am.
Your Honor, I have nothing else, may I be excused?
Yes, sir. Thanks, Mr. Kleins. Have a great weekend.
You too.
Thank you.
But I'm ready on Ms. Loomis.
Please. Yes, sir. Hello, Ms. Loomis.
Judge, appearing before the court is Cerise Loomis. We got two cases on the docket, 23 CF 1594 and 23 CF 369. As stated in my motion, Ms. Loomis was originally arrested on July the 14th of last year.
Right.
She was on probation. That was in case number 1594. At the time of her arrest, she was on probation as 23 CF 369. She's currently 40 years old. She resides in Crestview. She's lived there over 11 years. She's got two children, ages 10 and 8, who are currently residing with her father due to her being in jail. She works for her family business, which I believe is the Loomis Circus. Is that correct? The court previously set bond in case 23 CF 1594, and the defendant posted that bond on July 20th. 2023. However, she was rearrested for the VOP on August the 2nd of 2023, and there was currently no bond on 23 CF 369. On October the 9th, the court granted her a $5,000 signature bond with the added condition that she appear at all depositions if served with a subpoena to do so. Subsequently, she was served with a subpoena on November the 2nd to attend a deposition on December the 12th of 2023. She states that she was unable to attend that deposition. Subsequently, the state filed a motion to revoke her bond, and the bond was revoked on December 15th, 2023, and she was arrested on the Capias on December 26th, 2023. She's been in jail continuously since that date. She's previously been determined to be indigent. She does not have a lot of money to meet a high bond. We are expecting Ms. Loomis to plead straight up to the court on July the 8th, and there is a good probability that she will be sentenced to a term of incarceration. She does have property that she needs to secure, and she has some financial matters that she needs to address in case she does receive incarceration. She is requesting that her bond status be set to a signature bond with pretrial release or in the alternative, a $5,000 bond on both cases. I would also advise the court, Ms. Loomis has also been scheduled to see the psychiatrist, Dr. McDonald, for, I believe, June the 4th. She's scheduled to visit her, and that's for mitigation purposes. I believe Ms. Loomis would like to address the court as well.
Ms. Loomis, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Yes, ma'am.
Well, I would like to say, as far as the doctor, I believe that I would have no problems seeing the doctor on my own terms, meaning that we requested that wasn't the court's decision on trying to, that's what would be my benefit, or not my benefit if I didn't seek out and see the doctor. As far as missing the subpoena, which if it's of any relevancy had really nothing to do with my criminal charges. It was tacked on at the last minute. I had written a letter. I don't know if you were able to read that or.
I haven't, if I read it, if it was an ex parte communication, a one-sided communication, either I read it and then it wasn't, you weren't asking for something that I needed to act on at that time. You're represented by an attorney, so it'd be a nullity.
I understand.
Okay.
Well, in that briefly, I'll just touch a little topic of it. Missing the subpoena, I was under great stress. I right away was told to pack up my house, and I had to stay somewhere else for a while, and I had the kids. I had a stack of important papers. I wrote down the information on the calendar. I wrote one wrong number that has cost me. I tried to call and speak with her about it. She wasn't hearing it. I was willing to come in and talk to her. Either way, that has been addressed since I've been in here. It was a contempt of court. It was dismissed. I have dealt with that situation and all that is handled. During the time that I was out, I had several, well, not to say several, but a couple of court hearings with you. I have shown I've never missed a court date. My children desperately need me. I have our entire livelihoods, or I'll have nothing when I come out, even if I do time. I'd like to please just go out to be able to, I'm sorry. If I could just go out to handle these financial situations. My brother died last week. I'm sorry I'm crying.
Ms. Loomis, let me interrupt you a second. Mr. Nettle, refresh my memory on, because it seemed strange when I was doing my homework and it said, on the condition that she appear at all depositions if served with a subpoena. It's unusual to have a subpoena of a defendant. So tell me what those depositions were about.
This is her initial arrest. Well, actually, there was a young man apparently had spent the night at her house. I don't know if he's a family friend or whatever, but at some point he asked her 10-year-old son to drive him home.
Okay, but what was the deposition?
And that was, they found that the 10-year-old was driving the car with this guy in it, so they charged him with child abuse. And she was subpoenaed as a witness in that case.
Okay.
It wasn't her case. It was a case that's totally independent of her. Her child was at 10 years old. The guy asked him to drive him home because he drank too much, apparently. I don't know exactly the reason, but...
Okay, good, that makes sense. And Ms. Loomis, what you're saying is there was a lot of turmoil in your house around December 12th, and the paperwork just got messed up and you didn't show up.
I missed by one number. I wrote 9 and it was 12 or 14, whichever was the date, and I wrote one number off, and so I realized I called her and she just wasn't hearing it, and she issued a warrant. The trial advocacy center state's attorney contacted my criminal state's attorney.
So you thought the deposition was on the 9th?
Or I thought it was on the 19th, and I wrote that on the calendar. And it was
That makes sense.
prior.
Okay. To the state, questions for Ms. Loomis?
No questions for this defendant, Your Honor.
Argument from the state?
I kind of want to go back all the way to the original 23 CF 369 case, because I think it highlights the mentality that Ms. Loomis has with respect to her responsibilities to this court and the criminal justice system as a whole. She was originally offered a downward departure, or where she pled to 3 years, with the understanding that there would be a 4-year suspended sentence on that if she did not comply with probation. She then goes and gets the new law that's in 23 CF 001594. During that time, there was an issue with getting her to the deposition with DCF and the CAC. So when we had this bond here, we had an original bond hearing where this court granted her a $5,000 signature bond and this is after she had committed a probation violation, a new law violation, while on probation with a suspended sentence. This court still gave her another opportunity with a signature bond. And the only requirement that we had, other than to not commit any new law violations, was to appear at that deposition. If it was that important to her, you do everything in your power to be at that deposition. It was one of the only things that we asked of her to follow. If it was so important to her now, it should have been so important to her then to not miss those dates. Now we come back here, and not only has we're still in the same posture if she committed a new law violation while out on bond, but there really isn't any change of circumstances in that regard of why should I get a bond now versus then. And so, for those reasons, Your Honor, we feel as though this defendant in particular is not going to continue to follow the law. She's not going to follow the responsibilities that this court has set out. And so we would request that she remain without bond in the 23 CF 000369 case, pending the resolution of all of her cases, Your Honor.
Thank you. Mr. Nettle, finally.
Judges, my understanding, Ms. Lewis, her financial status, she tried to give somebody a power of attorney to handle her finances, and I guess pay her mortgage or whatever, and that person started stealing her money, so she's in a situation now, whereas I understand she's about to lose the property she's been living in for a long time. She's concerned because if she goes to prison, her children will have no place to live, and she needs to get out on bond so she can take care of the financial situation to try to secure the property she has in Crestview. Is that correct, Ms. Loomis? That's the reason Ms. Lewis has asked me many times to file for this bond motion, and I had basically argued with her about it, but I finally said, okay, let's let the judge decide.
Yes, sir. Ms. Loomis, a lot of things work in your favor, but the thing that works against you is the charges in the first case, the child neglect, DUI, and then the timing of the second charges, fraud, impersonating, use, possession of an ID of another, more so the resisting officer, obstruction without violence. The court has some concerns about the safety of the community, so respectfully, your motion to set bond is denied. So I'll see you back here no later than July 8th. Thank you, ma'am.
Thank you, Judge. That's all I have, sir.
Thanks, Mr. Nettle. Yes, what case are we going to do next? Counsel, Mr. Shaw, you're still standing.
Your Honor, if I may, I think that's all I have for this afternoon. May I be excused?
Yes, sir. Have a great long weekend. Memorial.
Be working.
Yes, sir.
Good afternoon, Judge.
Good afternoon, Mr. Shaw.
Judge Tim Shaw for Enrico Salmi. It is 21 CF 3018. We filed a motion for early termination of probation on behalf of Mr. Salmi. He's completed everything. He's more than halfway through his probationary term, paid all his fines. He's got his driver's license. There's no objection from his probation officer as well for early termination, and Mr. Snell does not object either, Judge.
Mr. Snell?
That's correct. I was just looking to see if
Okay.
there was any notes that she had on the case, but that's my understanding as well, that he's
Okay.
completed everything at this time.
Mr. Salmi, your case, your probation is terminated.
Thank you so much.
Thank you, sir.
I really appreciate it. Thank
Yes,
you.
sir, you're welcome.
Thank you.
Thanks, Mr. Shaw. Firm. Oh, okay. Thank you.
It's, Daniel Sledge.
Mr. Sledge? Right, that was, I've got it marked off my docket. I don't know.
On your update, it was taken off. Oh.
Okay, good. Hey, that's 1 for me and 100 for you. Okay. Mr. Sledge, to Madam Clerk, why was Mr. Sledge's case removed from the docket?
I think it was because originally, we got an email about it, that he had filed a pro se motion, which the committee was still on the case, so he asked to be removed. They removed it, but didn't put no attorney, so it didn't populate on the update.
Okay, so Mr. Sledge is not represented by the public defender?
No, sir.
Ma'am?
No, sir, he is not.
Okay. Mr. Sledge, what were you seeking in your motion?
Just probation termination.
Okay, if you'll give me a moment, let me look at it. Well, at some point I did my homework, but my JA probably removed it when you came off the docket, so let me look again.
Yeah.
And for Court Smart, it's 20 CF 2522. Correspondence 5-6. Okay, pretty bare bones, but saying that you've done everything that's required by probation and your probation officer doesn't have any objection. Mr. Snow?
I'm going to wait on Ms. Johnson. She's looking that up right now because
Okay.
I wasn't prepared for this one.
Understand.
Yep, everything's done, no objection.
Okay.
No objection from the state.
Mr. Sledge, your probation is terminated.
Thank you very
Okay?
much.
Thank you, sir. Good luck to you.
Have a good day.
Thank you, sir. You too. Okay, who's next? Mr. McKinney?
Judge, I have Doug Thompson in the court.
Okay. Hello, Mr. Thompson. Good, how are you?
This is on the docket as a VOP evidentiary hearing, however, we've reached an agreement.
Okay.
Mr. Thompson is going to be admitting the violation of probation. He will be adjudicated, he was previously adjudicated in this case. Probation is going to be reinstated and modified to the remaining amount be community control. All the original conditions are going to be reimposed. And there is an agreement for a modification back to standard probation after 12 months if all of his conditions are completed. There's a $100 BOP fee and a $150 cost of defense. May I approach with that agreement?
Yes, sir. Thank you.
And at the same time, I know that Mr. Thompson is going to have a question to a court related to cost of supervision.
Okay, thank you. Mr. Thompson, if you'll raise your right hand, your other right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Thompson, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Okay. Mr. Thompson, you had a question about the cost of supervision?
Since it was violation, I had to start staying in like hotels. I was staying in a hotel room in Pensacola. I'm paying like $400 a week to stay there, and then on top of that, just trying to keep my license active. They paying like $750, well, $750 a month in child support too. So
And how much money do you make per month?
about not even close to like maybe like $500 a week or something like that. Or whatever.
Okay. Strange question, but when did you buy that shirt?
This shirt, this is a gift.
Okay. Mr. Thompson, I do accept your plea. You're adjudicated guilty. Your current supervision is reinstated with all the original terms and conditions. However, it's modified so that and I'll say it the same way that your attorney did, the balance of your supervision will be community control. However, if at the 12-month mark you have completed all the terms of your supervision, haven't committed a new law violation, then your supervision will become standard probation. You'll need to pay the $100 cost of prosecution,
Yes, sir.
$150 public defender's fee, and how long does Mr. Thompson have left on his supervision?
He terminates in 2026.
May.
Okay. In the
16, 2026.
Okay, Mr. Thompson, I do waive the cost of supervision for the next 6 months, but after that, you have to pay the $40 per month.
Yes, sir. Thank you. Can I ask you one more question?
Yes, sir.
In between that time, like, say for instance, like a year or whatever.
We're not going to have a question, Judge.
Thank you. Thanks, Mr. Thompson.
Thank you.
Mr. McKinney, you have any other cases?
I do have Ms. Maria Rodriguez Barnes.
Okay, good. Yes, sir. For the trial,
Yes, Judge.
Mr. Rodriguez Barnes? Miss Barnes, thank you. There she comes. Hello, Ms. Barnes. Good afternoon. Let me find my notes. Okay. So, Ms. Barnes, I think that we're scheduled to go to trial on June 3rd through the 7th, correct?
Correct, with jury selection on the 3rd.
And how many do you want on the veneer?
Judge, in speaking with the state, I believe it would be appropriate for 140 on the veneer.
Okay. Madam Clerk told me this morning that jury management has, I don't know, maybe 500 that were scheduled, and that they'd only received 100 and something questionnaires back. So, but I did email jury management at 12:16 and said, here's what I know on the moment, gave them the layout, and said, if you do not have enough jurors for the Jordan case, Robinson case, then please prioritize and put Ms. Barnes' case as number one on receiving the jurors.
And for the record, and the reason for that request would be the nature of the case. It is a first-degree premeditated murder. It does involve a 5-month-year-old as the decedent. So there are factors of this case that I believe would warrant more than your normal amount of jurors. given the topics that we would be addressing at jury selection.
And Your Honor, if I may remain seated.
Yes, ma'am, absolutely.
Thank you. The state would concur on that request. The state would also ask that we pick 4 alternates in this case, given the nature and circumstances of the offense and some of the evidence presented. There may be a need to have more than 2 alternates.
Okay, we've got to have 12 on the jury, correct?
Yes, sir.
We don't have a jury box big enough for 4 alternates. We'd put fold-out chairs, I would think. We'd have, there's room for 2. I mean, they can put fold-out chairs, but they're certainly going to know that there's an alternate or 2 because of those. You're concerned that as the evidence comes on, that some of the jurors may seek to get off the jury because of that?
Yes, Your Honor. The evidence, as Mr. McKinney stated, this does involve the death of a 5-month-old baby, and it is a shooting death of a 5-month-old baby. The state has endeavored to narrow down the evidence and make it as least prejudicial as possible, but we still have to prove our case. What the state is afraid of is that there may be an emotional response to some of the evidence that would necessitate removing jurors before it prejudices Ms. Rodriguez, and we want to make sure that we have alternates available for that.
Okay. What I will say is maybe we'll at least have 2 alternates, but we may have 4. Let's see how the jury selection goes. I will ask Rachel to talk to jury management about a couple extra chairs just in case we need it. Okay? But we don't need to put those in the jury box until we get to actually picking. Okay. When can I get jury instructions?
Judge, I know the state has been diligent in working in jury instructions. They provided draft jury instructions to me already. I've already discussed the draft instructions with Ms. Rodriguez, so we are working diligently towards that end. But I'll allow the state to speak.
Think I can have them by Wednesday?
Absolutely, Your Honor.
Okay.
I could send you a copy of what I have now, but I'll wait and let Mr. McKinney make any changes, and we'll get those to you by Wednesday.
Okay, that'd be great. And then are there motions that I'm going to hear on Thursday?
There's a state's motion limine, which is scheduled to be heard today.
Okay, yes, and I'm glad you mentioned that this morning, because I didn't have that. One of the things you got to realize is, there's a big, long docket, and there's nothing that I was aware of that said that motion was being heard now. So when you mentioned it this morning, I wrote it down, I went, printed it out, but without you sticking it in my face, either by an email and say, look, Judge, docket number 12, because I have to figure out, that motion in limine wasn't filed yesterday, it was filed relatively long ago, at least on the docket. So you got to tell me what I'm looking for. Make sure I can do my homework, okay?
Yes, sir.
Okay, so I will 140, and then we'll see how many alternates, at least 2 alternates. Okay, on the motion in limine?
On the motion in limine, Judge, if we go by number, most of this is fairly standard, and if the court has the motion in front of it.
Well, I did when I was doing my homework. Let's see what I did with it, because I highlighted some different things.
The state has an extra copy, Your Honor.
Okay, yes, ma'am, I'll take it. Yes. Ms. Barnes, before you leave, I need to give you paperwork for the hearing tomorrow in the civil case that you have. That's with Gerber Life Insurance Company, but they didn't deliver a copy of the order setting that to you. I don't know why you were in jail. It said they were going to send it there, so I want to give you that before you leave. So please remind me of that, okay? Okay, let me look back. State's motion in limine. got it. I do have the one that I marked up. Okay, so, yes, on the state's motion in limine, what do you object to, Mr. McKinney?
Judge, from the defense perspective, there's no objection to number 1, that is standard language.
So that is granted.
There is no objection to 2.
It's granted.
Number 3, we would ask the court to potentially take that under advisement because we don't know exactly what would be said at trial or what doors might be opened.
Okay, and then I think at the end of the motion, number 13, it says if the court does that, nobody will let the horse out of the barn before I rule on the motion in limine.
Correct, and I did want to speak to that
Okay.
related to number 3 and number 4 specifically. And
Okay.
given the nature and the facts related to this case, obviously, we're not talking about specific facts at jury selection. But understanding through our questions to the potential jurors about their thoughts and experiences with mental health, potentially discussion related to suicide, I think that that is essential for us to narrow down and get an impartial jury. So I would not ask the court to strike that, but know that there is the distinction between jury selection and the questions we would be asking of other people that would be different from the evidence that would actually be presented at trial.
Any objection from the state, the court taking both of those under advisement?
No objection from the state. The state's position is that these are more geared towards trial, and perhaps the state should be more specific, but these are specific to the defense not coming in and merely stating Ms. Barnes has X condition without the proper predicate and foundation being laid.
Okay, so 3 and 4 are under advisement, but they relate to after the jury is seated.
Correct, Your Honor.
Okay. So then you don't have to worry about violating it during voir dire.
Yes,
Good. Okay, yes, sir.
5 appears to be standard, and the defense has no objection.
Okay, that's granted.
Number 6 is Florida Rule of Criminal Procedure, and obviously the defense has no objection.
It's granted.
No objection to 7.
I have some concerns with that because it says no reference shall be made to facts not admitted in evidence. If I took that strictly, it would mean you could never present any new facts. So I think it's really when. When are we talking about? Then the defense couldn't put forth any alleged new facts. They'd be violating that. Can't reference facts not admitted. I understand, I think what the intention was. If it's saying you won't reference, I don't know, in closing argument and openings, in closing argument, is that what you're talking about?
Yes, Your Honor, and we can, when we draft our order, we can make that specific to number 7.
Okay, so in closing argument, then with that revision, 7 is granted.
With that clarification, obviously, the defense is fine with that and understands where the state was going with that.
Yes, sir. Thank you.
Number 8 is standard, and we would have no objection.
It's granted.
Number 9 is standard, and the defense would have no objection.
That's granted.
No objection to 10.
Granted.
And no objection to 11.
It's granted.
It's the court's preference related to speaking objections.
Yes, sir. I just want to prevent any showboating in front of the jury. So 12 is granted.
Yes, sir. And 13 relates to really the previous 12.
Yes, sir. And so I don't think that's granted or denied, but that will certainly be the effect.
Yes, sir. And related to the state's motion in limine, that's what we needed to discuss.
Okay.
And I can certainly review the order as it's presented to the court by the state to make sure that we have no objections to that.
Okay.
Your Honor, I'll have that order drafted by tomorrow and sent to Mr. McKinney by tomorrow for his review.
Great, thank you. Okay, anything else from Ms. Barnes' criminal case?
Your Honor, I would just ask just a couple things about this right here. I wasn't anticipating still being on this for trial, but I think just to take care of a couple matters before we get in here for jury selection and to talk about and put on the record is my preference based on how this has been working out. For the record, the prosecution is on a mobility device for this trial. With the amount of evidence that we intend to present, it may be more efficient to bring Mr. McKinney up to the evidence and ask the court, may we approach, take all of the evidence over to the witness, make sure Mr. McKinney looks at each piece of evidence beforehand, and whether or not he has any objection to those, we deal with those at the bench so the jury can't, I think it would be more beneficial so the jury can't try to see what I'm trying to enter if they're at the time, and deal with those objections separately, perhaps anything that's objectionable before the foundation is laid, that we handle those objections. And then as I go through, of course, I'd have to lay the foundation, authentication, all that, and we would anticipate other objections. But that might be easier to do with the sheer volume of evidence with each witness.
Mr. McKinney's his eyebrows are furrowed, and I'm kind of a little... What I'd suggest is, why don't we try to address what we can outside the hearing of the jury?
Okay, and that's what I'm trying to do. I want to make sure that we try to do as much as possible outside the hearing of the jury.
Right, and without the jury in the courtroom, then that allows more flexibility of us, and then what we have to do before the jury, we'll do that. So let's try to do it when the jury's not in the jury box.
I'm fine with that. I think the primary concerns I have are Christy Hoffman, who is the CSI tech. She's bringing in a considerable amount of evidence. So if we want to give the jury a break beforehand, and then Mr. McKinney and I can come up, talk about whatever it is we need to talk about, and with the court, and figure out the most efficient way to do that.
Okay, good. Okay, thank you.
Judge, there's also an issue related to stipulations of fact. In speaking with the state has prepared a stipulation of fact as to the identity of the victim and the admissibility of certified records related to a driver's license. That's something I've discussed at length with Ms. Rodriguez, and I do have a copy of that is going to be filed with Madam Clerk that's prepared by the State Attorney's Office. I'm going to sign that and hand it back to Ms. Sandler.
Okay, thank you.
But while we're here on the record, I did want there to be a record of that.
Yes, Your Honor, I will take this back to the office and file it appropriately through the e-filing portal, but we have agreed to the identity of the victim, and we would ask to read these stipulations of fact into the record after opening statements.
Okay, yes, ma'am.
And we have included stipulations in the draft jury instructions. There is an instruction that needs to be read there.
Good.
And I did want to make some record while we are here in 20 CF 801 in that Ms. Rodriguez is charged with first-degree premeditated murder. There has not been an offer extended from the State Attorney's Office for anything other than as charged, and I wanted to make record of that.
In other words, straight up?
Correct.
Okay, meaning that the state hasn't offered any potential sentence?
Correct.
Okay.
And that's been provided to me in writing from the state, but I do want to make record that there have been plea negotiations, but there has not been any offer extended from the state.
Okay, thank you.
And just to make the record clear, for any potential issues that may come up in the future, Ms. Rodriguez Barnes did offer to plead to second-degree murder open to the court, and the state rejected that offer.
Okay, thank you. Okay, anything else from Ms. Rodriguez Barnes' criminal case?
Merely asking what time the court wishes to begin jury selection on June 3rd, given that there's going to be
8:30 on that Monday, if we'll be here, and then I'll ask for the jury to be ready at 9.
Yes, sir.
If there's anything else that comes up between now and like Thursday, just set it for 12:30.
So the next time that Ms. Rodriguez would be in court would be next Monday, absent us setting something special.
Would be a week from Monday.
Correct.
Right, correct. Okay.
And the court may have noticed that I've been referring to Maria Rodriguez as Maria Rodriguez instead of Maria Rodriguez Barnes. That's how the defense intends to present my client throughout the trial.
Okay, good. Okay. Thank you.
Any questions?
Okay, so Ms. Rodriguez, and for court smart, this is on a civil matter, so you don't have to take it down. But Ms. Rodriguez, I'm going to ask the bailiffs to hand you an order setting a hearing for tomorrow. It was filed with the clerk on April 12th, but it's a hearing tomorrow at 10:30. The jail said that they'll make you available via Zoom to attend to that. And then there's also a copy of the registry, how much money is in the registry left over from that, I believe it was a mortgage foreclosure sale. No? Okay, there's money in the registry, and you're the only defendant in that case, so it may just be us there. But I want you to understand what we're talking about tomorrow. There's about $63,000 left in that account. It was an interpleader, I'm sorry, it wasn't a foreclosure. The life insurance company put that money in the registry where they could walk away and say, you know, we know we owe this money, you've got to figure out who it goes to. At one point, they had an estate that was in there, but they dropped the estate from being a party to it, so it just has your name at this point. Okay. Nobody else is a party, so we'll talk about that tomorrow at 10:30. Okay. Thank you.
And Judge, simply because it's mentioned on the record and we're in court, is that anything that counsel in the criminal case needs to attend?
It's a civil case. No, sir. Not that I'm aware of.
You know what we're talking about?
I'm just not aware of anybody else making any claims toward that money. The plaintiff didn't name anybody else as having an interest in it. You know, so I'm not aware that I have to put the world on notice of what that is.
Yes, sir.
Okay. So I'll see you tomorrow at 10:30.
Yes, sir.
Thank you, ma'am. Okay. On the last hearing that we have scheduled, how long is that going to take? Do we need to take a break? Go ahead and do it.
It's in prison, so I'm not sure.
I think it's supposed to be like a 30-day hearing, but I don't know.
Is this Timothy Reagan?
Yeah.
Oh, this is the one the court already filed an order on this case?
No, I see it's filed in a one case. The other.
So we just need to tell Mr. Reagan that?
He wasn't transported, he's in, so he receives someone.
Okay, so Mr. Reagan's not present,
No, sir.
and this is 22 CF 29